Thank you. I think we're ready to begin.
Okay, we're on.
Thank you very much, Commissioners Alisi and Sayre. I would like to call this session of the Public Service Commission to order. Assistant Secretary Agresta, are there any changes to the final agenda?
Good afternoon, Chair and Commissioners. There are no changes to the agenda.
We have one item for discussion, which is jointly two items, item 501A and 501B of case 15M0388, which is the Charter Communications and Time Warner Cable joint petition for approval of a transfer of control, reorganization, and financing arrangements presented by John Sipos, Acting General Counsel. Graham Jesmer, Assistant Counsel, and Joseph Yackel, Utility Supervisor, Office of Telecommunications, are available for questions. John, please begin.
Good afternoon, Chair Rhodes and Commissioners. There are two items before the Commissioner today in case 15M0388. The first item, number 501A, concerns a proposed order for the Commission's consideration that, among other things, directs the Commission's counsel to initiate an affirmative civil enforcement case against Charter Communications for various violations of the Commission's January 2016 order that approved the merger of Time Warner Cable and Charter Communications, subject to specific conditions and obligations. A central and critical condition in the Commission's January 2016 approval order required Charter to expand its network so that the network would, quote, pass, close quote, an additional 145,000 unserved or underserved residential or business units in less densely populated areas of the state within 4 years of the closing of the proposed transaction, that is by 2020. This obligation is known as the Network Expansion Condition. The approval order required that Charter complete no less than 25% of this total in each of the 4 years. And as a first step, Charter was required to pass 36,250 residential and or business units by May 18, 2017. However, Charter failed to achieve that requirement. And as a result of that failure, the Commission and Charter entered into a settlement agreement establishing revised binding network build-out obligations. Pursuant to the settlement agreement, Charter was, among other things, required to meet new milestones by passing 36,771 residential or business units by December 16, 2017, and 58,417 residential or business units by June 18, 2018. Again, the passings were to occur in less densely populated areas of the state. However, Charter also failed to achieve these requirements. On June 14, 2018, following a process that included additional administrative enforcement actions here, including an order to show cause, and Charter's various responses thereto, the Commission, among other things, disqualified 18,363 proposed passings from the company's December 16, 2017 build-out report that was filed on January 8, 2018, because, among other things, many of those addresses were in the densely populated urban cities within the state, including New York City. That determination caused Charter to fail to satisfy the required approximately 36,000 new passings target. There can be no dispute whatsoever that New York City is not a less densely populated area relative to other areas in New York State. In fact, it is the most densely populated area. On July 9, 2018, Charter submitted its update and bulk address report, which provided the Commission with the company's purported number of additional passings as of June 18, 2018, and an update of its compliance status concerning the build-out plan. Following Charter's most recent filing, the Department staff initiated further review of the passing addresses contained therein. And based on charter submissions, it is staff's position that charter has not provided the required public interest benefit for upstate New York counties and communities, and that charter thus has not complied with its regulatory obligations and requirements. By way of example, it is staff's position that charter's actions and accounting practices have negatively impacted citizens living in various counties such as Yates, Steuben, Niagara, Genesee, Franklin, and Clinton counties. And that is because there's an inverse relationship for addresses that are in New York City. If they are to be added, there are addresses in upstate areas that are subtracted. The draft order before the Commission today provides a pathway for the Commission to determine that Charter has failed to satisfy the settlement agreement's June 18, 2018 target by more than 22,000 passings, and furthermore, that Charter has not made sufficient good cause showing for this latest miss. And as a result, the draft order addresses also the forfeiture of $1 million from the letter of credit facility under the 2017 settlement agreement. In addition, the draft order discusses the termination of the settlement agreement's, quote, sole remedy, close quote, provision. And lastly, in light of the repeated ongoing and expanding violations of the regulatory requirements, the draft order directs the Council to the Commission to commence an affirmative civil litigation in New York State Supreme Court pursuant to public service law in the name of the Commission and the people of the state of New York to seek the imposition of civil financial penalties for such violations and an injunction to compel Charter to comply with the June 18, 2018 requirement. Civil financial penalties are a means to vindicate the Commission's regulatory authority, penalize Charter for its violation of regulatory obligations, and, importantly, deter other regulated entities from engaging in similar conduct that violates Commission orders. This concludes the presentation on item 501A. We would be happy to answer any questions that the Commission has.
I have no questions. I find that this is a record of repeated and worsening failures and violations of the order today on their performance to date, and that we absolutely must seek remedies. I find this recommendation to be appropriate and necessary, and I intend to vote in favor. Commissioner Sayre?
My comments relate to both items since they're pretty well intertwined. I can say that I'm very sorry that we have to take these steps, but I'm convinced that we have to take these steps. From my viewpoint, it appears that Charter decided, apparently for financial reasons, to substitute low-cost connections in New York City and some upstate cities in place of higher-cost passings in less densely populated areas. This does not meet our requirements, which Charter accepted for the build-out. It works a grave disservice to thousands of upstate customers whom Charter has removed from its build-out plan. From its latest filings, it is apparent that Charter is moving farther and farther away from its commitment, not closer. We've given Charter ample opportunities to get back on track, but it refuses to do so. Accordingly, I have concluded that these extreme steps are necessary, and I will vote in favor of the orders.
Thank you. Commissioner Releasy.
Thank you. It's actually sad for me to say that I can endorse this and that I will be supporting it. We never like to see such strong action taken against a business, but in the case of a business that is not doing what it says it was going to do, it's not just hollow promises. It is also working to the detriment of those people that were seriously and hopefully relying on the opportunity to have reliable service. And for other reasons as stated earlier, but I will be supporting the initiative.
Thank you very much. John, can you proceed to the next item?
Yes, Chair. So the second item, number 501B, concerns a draft order for the Commission's consideration that addresses Charter's petitions for rehearing and reconsideration of the Commission's June 14, 2018 orders, and also discusses the revocation of the January 8, 2016 order approving the acquisition of Time Warner Cable. And for the reasons stated therein, this second draft order denies the company's petition for rehearing and reconsideration of the Commission's previous orders, and as discussed below, and finds that Charter's performance in attempting to comply with the approval order's network expansion condition and related matters is deficient, and its behavior before the Commission has been contrary to the public policy to such an extent that the Commission should exercise its authority to revoke and rescind the approval order. And by way of background, in approving the acquisition and merger, the Commission stated that for the transaction to meet the enumerated statutory public interest standard, it must yield positive net benefits, and after balancing the expected benefits properly attributable to the transaction, offset any risks or detriments that would remain after applying reasonable mitigation measures. As part of its review, the Commission concluded that additional, quote, enforceable and concrete conditions, close quote, were needed to satisfy the net benefits test. Otherwise, the merger between Charter and Time Warner should be and would be denied. Accordingly, the Commission explicitly conditioned its approval on a host of conditions designed to yield incremental net benefits to New York. The most critical of these conditions required Charter to expand the company's network to, quote, pass, close quote, an additional 145,000 unserved and underserved residential or business units within less populated areas of New York. As noted in the earlier presentation of item 501A, Charter did not comply with the binding obligations concerning the network expansion and build-out in unserved and underserved, less populated areas of the state of New York. In fact, Charter repeatedly missed its build-out obligations. Recent filings by Charter reveal that the shortfall has increased. That is, Charter has fallen further behind in its build-out obligations for the less populated areas of the state. And as noted, over the last several months, the Department and the Commission have taken various affirmative administrative enforcement steps to bring Charter into compliance. Those actions have included the 2017 settlement agreement and the 2018 order to show cause. Charter, however, has continued to maintain positions that are contrary to the 2016 approval order. And on June 14, 2018, the Commission issued two orders, one that rejected Charter's proposed accounting concerning numerous passings that it tried to argue somehow would satisfy the approval order, and that order also determined that Charter had not provided good cause for its violation of the December 16, 2017 build-out obligation. The Commission also concluded in that order that Charter had failed to remedy its missed December 2017 target by the settlement agreement's March 16, 2018 cure deadline, and failed to make a sufficient good cause justification in that regard, and that resulted in the forfeiture of its right to earn back an additional $1 million in accordance with the letter of credit and the settlement agreement. In addition, in a second order also issued on June 14, 2018, the Commission also released a companion order on Charter's limited, conditional, and qualified acceptance of the approval order's condition. On July 16, 2018, Charter filed two administrative petitions for rehearing and reconsideration on the Commission's June 14 orders. The draft order before the Commission today denies those petitions for rehearing and reconsideration. Today's draft order also discusses Charter's actions and contentions in terms of the build-out obligation. The order discusses the various administrative enforcement steps that the Department and the Commission have already taken to correct Charter's behavior and secure its performance with the approval order's network expansion condition. These steps were all insufficient, unfortunately, to secure Charter's compliance with the network expansion condition. Charter instead opted to include addresses in its network build-out that were neither unserved nor underserved, including many addresses in densely populated areas. Over the last 2 years, Charter has, among other things, obscured and obfuscated its build-out performance, not complied with safety standards, and sought to use its limited and conditional acceptances of the approval order to effectively change the terms of that order. A review of Charter's conduct over the past 2 years reflects, unfortunately, an absence of an unconditional commitment to compliance to the New York regulatory framework and the company's obligation. The continued efforts, among other things, to use the New York City locations and thereby exclude unserved and underserved areas in upstate New York also reflects a lack of commitment to compliance. In short, Charter has had repeated opportunities to demonstrate its commitment to the Commission's approval order and settlement order, to modify its build-out actions to comply with the network expansion condition and also advance the public's interest. But it has not. For the reasons discussed in the draft order, Charter has consistently violated the approval order and the Commission's laws and regulations. Those repeated violations support the rescission and revocation of the January 8, 2016 approval order and require that Charter cease operations in New York subject to the conditions laid out in the draft order in the Public Service Law. This concludes the presentation on item 501B. We would be happy to answer any other questions that the Commission has. Thank you.
Thank you, John. I find that the company's conduct and deliberate and sustained failure to perform and continued and sustained violation of its commitments is simply not serving New Yorkers, nor is it serving our public interest standard. We need to seek a different provider. And I also find that the grounds for denying the petition for rehearing are on the mark. I will be voting in favor of this recommendation. Commissioner Sayre, you thought that your comments might cover both of these orders. I don't know if you want to add.
I concur with the chair's comments just made on the second order, and I'll stand on my prior comments.
Thank you, Commissioner Lisi. Do you have anything to add, or do your prior comments cover both?
I concur, and I have nothing more to add. Thank you.
With that, I will proceed to call for a vote. For item 501A, my vote is in favor of the recommendation to confirm Charter Communications missed June 2018 compliance obligations, to deny Charter Communications good cost justification, and draw upon the letter of credit in the amount of $1 million, and to direct counsel to the Commission to commence a special proceeding or action as discussed. Commissioner Sayre, how do you vote?
Aye.
Commissioner Lisi, how do you vote?
Aye.
The item is approved and the recommendations are adopted. We'll move to item 501B. My vote is in favor of the recommendation to deny Charter Communications' petition for rehearing and reconsideration, and to revoke and rescind the approval order, and to require Charter Communications to file a plan with the Secretary and not abandon any regulated service during a period of orderly transition, as discussed. Commissioner Sayre, how do you vote?
Aye.
Commissioner Lisi, how do you vote?
Aye.
The item is approved and the recommendations are adopted. Assistant Secretary Agresta, are there any further items to come before us today?
There is nothing further for today.
Thank you. With that, we are adjourned. Thank you.